Welcome to the deep dive. Today, we're looking at fundamental rights in the Indian Constitution, but not just listing them out. We really want to get into their philosophical core, and the kind of power they give individuals.
Exactly. And that's the critical point. These aren't just words on paper. They're essential conditions for a person's dignity, their full development, the main goal, to make sure we have rule of law, not rule of people. It's a check on government power.
Okay, let's try and unpack this a bit. If a fundamental right is so important, what really sets it apart from, say, a regular legal right, like the right to vote?
Right. Well, the difference is pretty stark. It really comes down to the source of the guarantee and how strong the protection is. Fundamental rights, they're baked right into the Constitution, Part 3 specifically. And if they're violated, you can go straight to the top courts. A legal right, though, that comes from ordinary laws made by Parliament.
So easier to change.
Much easier. Parliament can amend or even get rid of it with a simple majority vote. Think about the right to property.
Ah, yes. Good example.
It used to be a fundamental right, but the 44th Amendment back in 78, it moved it, downgraded it, essentially, to just a legal right under Article 300A.
Yeah, the consequence.
The big consequence. You lost that direct line, that Article 32 route, straight to the Supreme Court if that right was infringed. That pathway is strictly for fundamental rights.
Okay, this is where it gets really crucial. These rights protect you against something called the state. But defining the state, isn't that incredibly complex? I mean, who exactly is the state here?
Well, that's Article 12's job. And yes, it casts a very wide net. It includes the obvious ones, central government, state governments, local bodies like panchayats.
Right.
But importantly, it also includes other authorities, even semi-governmental bodies getting state funding. Think LIC, ONG, side bodies like that.
Why so broad, though?
It's philosophically vital. It stops the government from, just farming out its functions to some other entity to dodge its fundamental rights obligations.
Got it. And then Article 13 comes into play, the judiciary's role.
Precisely. Article 13 sets up judicial review. It basically says any law that clashes with a fundamental right is, void to the extent it clashes. The courts are the watchdogs.
Let's zero in on Article 21 then, right to life. It sounds so simple in the text, but its interpretation has been revolutionary, hasn't it? What was the old sort of narrow view?
Before 1978, it's quite narrow. The phrase procedure established by law was taken very literally. Courts would mainly check if a law existed for taking away life or liberty, not really if that law was fair or just.
So a technically legal injustice was possible.
It was. But the Maneka Gandhi case in 78 completely changed that. The Supreme Court said, no, the procedure itself has to be just, fair, and reasonable. It couldn't be arbitrary or oppressive.
That's a huge shift. It means the law must have substance, not just form.
Exactly. And that single decision blew Article 21 wide open. Life wasn't just about breathing. It meant living with human dignity. That's how we got rights like clean environment, health, privacy, even the right to sleep, folded into Article 21.
Wow.
And Maneka Gandhi also cemented what we now call the Golden Triangle, that Articles 14 equality, 19 freedoms, and 21 life aren't separate silos. They work together, reinforcing each other. They form this unified protective shield.
So, okay, the shield exists. But what if it fails? What's the absolute guaranteed way to get justice if a fundamental right is violated?
That brings us to Article 32, constitutional remedies. Dr. Ambedkar called it the soul and heart of the Constitution for a reason.
Why that specific phrase?
Because Article 32 is what makes these rights real, enforceable. It gives you the right to go directly to the Supreme Court. And crucially, the Supreme Court cannot refuse to hear a case under Article 32 concerning fundamental rights. It issues writs like habeas corpus against illegal detention, powerful tools to enforce these rights immediately.
So the courts protect the individual's rights. But thinking bigger picture, what stops Parliament itself, maybe with a huge majority, from just changing the Constitution and weakening these core rights?
The ultimate safety net. That's the basic structure doctrine. It came out of the massive Kesavananda case in 1973.
Right, the landmark case.
It essentially said, yes, Parliament can amend the Constitution, but it cannot destroy its fundamental essence, its basic structure. Things like democracy, secularism, judicial independence. They're off limits. They can't be amended out of existence.
So it protects the core identity of the Constitution from being fundamentally altered.
Precisely. It's a check on absolute parliamentary power, ensuring the foundational principles remain intact.
So the big takeaway here is that fundamental rights aren't some dusty old text. They're alive, they're dynamic, constantly being shaped and reshaped by the judiciary to face new realities.
Absolutely. And consider this. Since the 44th Amendment, Articles 20 and 21 protection regarding convictions and the right to life, they can't be suspended, not even during a national emergency.
That says a lot about their importance.
It speaks volumes. They represent the absolute minimum guarantee of human dignity. Now, think about how Article 21 keeps expanding privacy, environment. It really raises a question, doesn't it? With technology like AI advancing so rapidly, how do we, or how should we, incorporate protections related to these new challenges within that existing Golden Triangle framework of equality, freedom, and life? That's something for you, the listener, to really chew on.